Apologies for the slight delay. Who's going first?
So I think it's me.
Right, fine.
So first of all, we are of course grateful for this opportunity to make oral submissions at the close of phase 2 of this inquiry. To frame these submissions, these are not our final position on the evidence, but it's our attempt to assist the inquiry with its examination of evidence within the future phases as we go forward. The inquiry will have to decide whether what we've heard in phase 2 is the result of cock-up or cook-up. If cock-up, an archery term, sir, then it is the result of a serious failure to care about the fitness for purpose of the Horizon system and speaks of contempt for sub-postmasters. Worse than that, if that could be possible, is cook-up, meaning that once the imperfections of the Horizon system were known within the Post Office and Fujitsu, both contracting parties were left with a less than satisfactory Horizon system, but nevertheless decided to carry on in the pretense that the system was adequate for branch use and also capable of providing evidence, reliable evidence, sufficient to blame sub-postmasters for shortfalls, to support investigations, to deal with civil actions and prosecutions. The problems within the Horizon system are not limited to the bugs within the software examined by Mr. Justice Fraser, but also hardware, installation, environmental interference in Horizon internal communication, disconnection and reconnection, bad training, bad scripts, and bad advice from the unhelpful desk. The evidence within phase 2 has highlighted particular themes, and we say these are significant. First of all, the inappropriateness of the private finance initiative in the procurement of Horizon. What guidance, protocols and systems were in place to support the use of the Horizon system for making claims against sub-postmasters for shortfalls or taking action against them in the civil courts or for investigations and prosecutions. What was the extent of knowledge within pathway of the inadequacies in the Horizon system? Who knew what and when? And so far, sir, fairly obviously, we've heard evidence from managers and more senior individuals. We anticipate later on that we'll be hearing evidence from people working within the organisation. How far did that filter through? The same question, the extent of knowledge within POCL of the inadequacies in the Horizon system. How far was that knowledge of the difficulties with the system, its problems, fed through to those people working day to day within POCL? And finally, we asked the inquiry to consider what the effect of this is. The decision taken by POCL to design out the ability of sub-postmasters to interrogate the system. The reason why we ask the inquiry to keep these themes in mind as we go forward within this inquiry is because we suggest that we are going to need to consider what evidence there is which may demonstrate that a cover-up did not start after Simon Clarke blew the gaff on Mr. Jenkins within the Post Office, but much earlier. The evidence in phase 2 confirms that Horizon was never capable of supporting criminal or civil actions against sub-postmasters. And so, as you're aware, we've been pursuing this particular track in the questions that we have been putting to witnesses. There's been considerable mention of Section 69 of the Police and Criminal Evidence Act, which dealt with the admissibility of computer-based evidence, which was, at the time when it was in force, meant that such evidence was subject to a requirement for a party wishing to rely on such evidence to demonstrate that the computer had been operated properly and that it worked properly. This has been referred to as a certificate. Going back a little bit further in time, in 1995, the Law Commission held a consultation on proposals to get rid of the Section 69 safeguard and introduce a presumption that a computer system has operated correctly unless there is explicit evidence to the contrary. Pockle actively supported the proposal to get rid of that particular safeguard and argued in written representations dated the 31st of July 1995 that the safeguard in Section 69 was too strict and had the effect of hampering prosecutions. These submissions were made by the head of Post Office Limited Criminal Law Division, Miss Churchard, and they were made to the Law Commission on the 31st of July 1995. Now, so this is material that we provided to the inquiry. As yet, as far as I know, we don't yet have a relativity reference for it. The submissions, though, made by Ms. Churchard were briefly as follows. In practice, the operation of Section 69 of the 84 Act is somewhat onerous from a prosecution viewpoint. I consider that computer evidence is, in principle, no different from any other sort of evidence, and it should, in general terms, be admissible, so that any argument in court would relate to its weight rather than its admissibility. I therefore, she went on to say, I therefore consider that there should be a presumption that the machine is in working order, etc., and if the defence wish to argue otherwise, then clearly they should be able to do so. She finished. At present, I therefore consider the evidential requirements to be far too strict and can hamper prosecutions. Now, that was a written submission made in July of 1995. We need to therefore bring things a little bit further up to date within the time period of matters that we've been dealing with. I'm going to take you to a document that should be able to go on the screen, which is FUJ 000058182. Now, this is the monthly progress report, and I'm going to take you to the part that deals with under security system, and it is the 6th bullet point. If that, Paul, could be put on the screen, and if you could bring out the discussions took place, the 6th bullet point, starting with discussions took place, and highlight that. Thank you. So this is dated on the face of the first page of the document. It's May 1999. The internal pagination is also headed the 14th of June 1999. So it's issued roughly in the middle of 1999. Discussions took place with Pockle Investigations and legal staff to progress the provision of Section 69 PACE certificates. Pockle are clearly anticipating a comprehensive fraud and prosecution support service from ICL Pathway. We've made it clear that this is not in the core contract. It represents an opportunity for a non-core service. Now, quite putting aside for a moment that ICL, operating as a private company, is wishing to make more money out of providing an extra service, the point that we're referring to here is that at this stage, in the middle of 1999, it is clear that there were discussions between Pockle and ICL in order to provide a system that would support. We know that by July of 1999, the document that we see now a number of times, which is the codified contractual agreement reached between Pockle and ICL Pathway, the clause that we don't need to put on the screen, so you're very familiar with it, clause 4.1.8, which is the clause within the codified contract that sets out that the contractor shall ensure that all relevant information produced by the Pockle service infrastructure at the request of Pockle shall be evidentially admissible and capable of certification. So we know as we go through these dates in 1999, by May of 1999, the monthly progress report is stressing that there needs to be a system. There's a discussion about that and how that system will operate. By July of 1999, the Section 69 contractual requirement was embedded within the codified agreement. So we know that Pockle and Pathway were tracking the investigation and prosecution issue. Now, as a matter of fact, Section 69 was repealed on the 14th of April 2000. A subsequent version of the contract, dated 2002, whose reference is FUJ 6074, was amended to remove the Section 69 references. And so at an earlier stage in questions that we asked, we showed that particular document. So at the moment, as far as we're aware, we have the codified agreement and then the contract dated 2002. Now, that's subject to later disclosure. We can see, therefore, that this question of evidential admissibility in relation to prosecutions was a matter that was under discussion between the parties over a considerable period of time. Now, it was the view of Pathway that Pockle ought reasonably to have known about the problems in the system. Mr. Oppenheim told the inquiry in his evidence that he had always assumed that any request made by a post office for data to support a prosecution would be a rare thing. He said that there was a general understanding between all the technical and commercial people that there would be occasional errors. He said that everyone knew that there would be mismatches, and that his presumption was that the post office would, certainly at the outset, give sub-postmasters the benefit of the doubt. And you'll recall his evidence, which was given on the 26th of October, page 48 of the transcript. And so we've heard also from Mr. Johnson, who said that in his evidence very recently, that he expected, or made an assumption, as he put it, he made an assumption that there would be a break, a period of time whereby the system wouldn't be used to support prosecutions. Perhaps a shakedown period or something similar to that. Yet there is, in fact, no evidence of sub-postmasters being given the benefit of the doubt. We know that because of Miss Locke, a 25-year sub-postmaster veteran by the time of the installation of the Horizon system, who began to see inexplicable shortfalls in January of 2000, investigated in mid-2000, and prosecuted in 2001. There was no pause, there was no break, there was no let's see how this shakes down. The reality was that Pockle were in a catch-22 position of their own making. Having automated the accounting system in branches, they could no longer bring a prosecution or civil action, or indeed question a shortfall without relying on Horizon as the sole source of evidence. But equally, there is evidence that they knew that Horizon was not up to the task and could never attain what Andrew Simpkins told the inquiry on the 3rd of November amounted to the very high bar if it was to perform that function. And so you will recall Mr. Simpkins in the witness box, when he was asked that question, I think it was by myself, that he described that physically as well. And he put his hand up in the air to say that the bar was up here. If you wanted the system to work to that level of functionality, then it would be a very different thing indeed. That's transcript, 3rd of November, page 116. There is evidence, we suggest, which at the very least is suggestive of suppression of these issues within Pockle. John Roberts, a former managing director of Poll, when giving evidence on the 20th of October, told the inquiry that the issue of prosecutions was never raised in discussion at senior management or at board level. We also heard that the matter of prosecutions was dealt with by the internal solicitors department at the post office, who reported, I think it was to Mr. Roberts himself. We urged the inquiry to ensure that members of the legal team within the post office are called to give evidence in the appropriate phases in this inquiry in the future. And that would include references that we've had to Mr. Christou and Ms. Churchard. Now, the extent of knowledge within Pathway of the inadequacies in the Horizon system needs some short examination. Pathway certainly knew that the Horizon system was not capable, we suggest, of supporting a civil or criminal claim against our postmasters, let alone justifying countless suspensions, dismissals, menacing demands for repayments in respect of so-called monies that the post office said was missing. Jeremy Folks, a former infrastructure assurance team leader at Pockle, gave evidence on the 2nd of November and confirmed Pathway's attitude. He said, as regard acceptance issues, that Pathway were more interested in talking down severity of acceptance issues rather than actually trying to engage to resolve issues. He referred to a war of attrition and stated that Pathway had a massive incentive to avoid any acceptance issue, being classified as a Category 1 issue, which he described as a showstopper. The scale of the problem and Pathway's knowledge of it was explained in the evidence of David MacDonald, a former development manager at ICL who gave evidence on the 16th of November. His evidence is important, not the least because his evidence was untroubled and uncontested by any oral questions from Fujitsu or the Post Office. We imagine that Mr. Justice Fraser in the civil claims and the hearings that he dealt with and the Court of Appeal in the criminal appeals would have been very interested in what he had to say. Was the reason, or is the reason, that Mr. MacDonald's report and his evidence was not disclosed within the High Court litigation, that Fujitsu was not a party to the proceedings? And is this a consequence of the PFI nature of the contract and its consequential black box? Mr. MacDonald confirmed, joining ICL just after, I think I recall, Easter of 1998, that it became obvious to him that of the team of 8 developers at Pathway, 4 were not capable of producing professional code, that there were no development standards or methodology. Some of the design specification documents were reverse engineered, written to reflect code, pre-existing code. Incredibly, there was no overall design specification, and many documents served no function other than to satisfy an audit for the purpose of meeting acceptance criteria. Furthermore, he said that basic steps such as coding standards document and peer reviews were absent. Neither were there any unit testing standards, so it's not possible to test the code. Mr. MacDonald said that the constant high level of pinnacles being raised daily and the fact that the number of these was not diminishing were becoming more complex led him to conclude that the quality of the code was not right. Transcript 16th of November, page 19. Now, these concerns led to the task force initiative between August and September 1998 and the joint report produced by Mr. MacDonald and Mr. Holmes. Significantly, Mr. MacDonald said that the code was so bad that he'd never seen anything like it in the 25 to 30 years since his involvement in the Horizon project. The effect of this was that the need for constant rewriting of bad or unreachable code would cause code decay, leading to the whole product becoming unstable. Furthermore, Mr. MacDonald confirmed that the EPOS product was developed using Rapid Application Development, RAD, directly from the prototype, a process which was fatal in a large project with several integrations. Mr. Beer, against counsel, described this as building on balsa wood. Transcript 16th November, page 59. Despite Mr. MacDonald and Mr. Holmes' conclusions, their report was not accepted by Mr. Austin, the program director, and was disregarded by Mr. Jenkins, the senior Fujitsu architect who was much later the subject of the Simon Clark advices, criticism by Mr. Justice Fraser, and, we understand, an ongoing Metropolitan Police Service investigation. Shortly after the publication and distribution of the task force report, Mr. MacDonald was offered a promotion. He said he would only accept that promotion if the Horizon cash account code was rewritten. ICL will not do that, and Mr. MacDonald was moved sideways, perhaps conveniently. Mr. Scipione commented on the task force report on his second appearance before you on the 27th of November. Mr. Scipione described how disturbing it was to read that there was no design for the EPOS system, of the Horizon system, and considering that where there's a lot of pinnacles and peak errors were, the lack of design specifically led to the imbalance issues. Put simply, he said, if you're not going to design something properly, it's not going to. If you don't have a good design, it's not going to work properly. In his report, Mr. Scipione had not been aware that the EPOS system had been developed using Rapid Application Development, as that had come out during the evidence of Mr. MacDonald. When this matter was put to him on the 17th of November, Mr. Scipione articulated further concerns as to the integrity of the Horizon product. He said, RAD almost means no plan, other than, I think I know what the goal is, and I'm going to get to that goal as fast as I possibly can. And there's good situations where that's needed, but this is not the right situation for that. You need to do everything in a very methodical, almost militaristic way to make sure that everything works properly together. Because I think I mentioned before, there are so many moving pieces This has to be highly coordinated. RAD is the other end of the spectrum. It's not highly coordinated, or it doesn't support coordination amongst big teams, because that's not the purpose of RAD. RAD is get it done quick, get a little bit done quick. 17th of November, page 153. Mr. Sipien commented on some of the examples that have been given by Mr. MacDonald, stating this is terrible code, this has to be a joke. In relation to another, he said, it's just not the right structure. It indicates to me that they don't understand what those particular structures are, and just take my word for it, they don't understand what the structures are. Pathway had been alerted to the grave shortcomings, but we suggest suppress this information and push for acceptance. Through the evidence in the forthcoming phases, we need to understand who knew within POCL of the Horizon system's shortcomings and how that knowledge was employed when hounding sub-postmasters for shortfalls, investigating them or prosecuting them. Our clients have urged me to submit that any protestations by the Post Office to the effect that they were misled by Pathway should be rejected. The Post Office are just as culpable as ICL, Pathway and Fujitsu, if not more, because they have a direct duty of care. And morally, the hundreds of years of service provided by sub-postmasters since the foundation of the Royal Mail should have underlined the need for them to make sure that the system worked and was functional. So far, what we have seen is a lack of governance, lack of oversight, and lack of recognition by the Post Office, and we suggest that is indefensible. So the question that my clients would particularly like you to pursue is one, in fact, you raised on the 3rd of November when referring to Mr. Folkes' evidence. And it relates to paragraph 207 of Mr. Folkes' witness statement. And he said there, I think it's actually between paragraphs 206 and 207, Mr. Folkes said, given the problems in 1999 from acceptance and throughout the project, I believe clearly that the system and Pathway had some significant way to go to gain confidence. To a degree, in 1999, this was a classic don't start from here situation. It is very difficult to retrofit quality to an IT system, and it would appear from our experience that Pathway had applied a fix-on-fail approach to some areas, e.g. EPOS, with many fixes being applied in 1999 to get it through acceptance. This was not an ideal basis from which to move forward, he went on to say at paragraph 207, and it would have been appropriate to apply some healthy scepticism to the operation of the system over the first few years. He said this, I think a key question for the inquiry to ask is what gave POCL such confidence in Horizon to start using it for prosecutions of sub-postmasters, especially after the rather checkered history of the system from 1996 to 2000, and in particular, the experiences of 1999. It can't have escaped the inquirer's notice that even a short mental chronology of the history of this means that there was a hurtling towards get this thing going, get it working, get it out there. For these reasons, sir, we say that the inquiry must dig deep into investigation and prosecution processes. The evidence in phase 2 of the inquiry has laid a very solid foundation for this exercise to be undertaken. Mr. Jerem, the head of Digital Systems Platform Unit at Fujitsu, gave evidence on the 10th of November and confirmed that Post Office took a decision, which he says was not taken quickly, that there was to be no paper cash account. Mr. Jerem agreed that the effect of this decision was that sub-postmasters were prevented from interrogating the system and checking their records against allegations of shortfalls. He also agreed that the ability of sub-postmasters to check their records was deliberately designed out of the Horizon system. Transcript, 10th of November, pages 141 to 142. On behalf of our clients, we suggest that this shows a degree of premeditation by POCL, as POCL wanted to ensure, through the design of the system, that sub-postmasters would be less able to examine the system. It would undermine their ability to defend themselves against demands for money when the system, as it did, inevitably failed. Mr. Jerem says at paragraph 16 of his statement that Post Office took the decision to dispense with the paper count system, with the paper case system. And you know, sir, that this was a very big issue for the sub-postmasters, because previously to the introduction of Horizon, they could go back through their own records. After the introduction of Horizon, they were not able to go through the same exercise. The inability of sub-postmasters to interrogate the Horizon system when faced with demands for sometimes large amounts of money based on shortfalls caused our clients to suffer from sustained high-level anxiety and a sense of utter and complete powerlessness. We ask how that happened, how those decisions were made, is fully explored in the future phases of this inquiry. The PFI initiative. The evidence in phase 2 has largely, well, not largely concerned, but has concerned a procurement that went horribly wrong. Mr. Milburn, in his evidence today, I think at the timing I clocked it out as 10:35, described PFI as being a transfer of risk. And we need to understand how this particular private financing initiative worked in this particular procurement process. Because what was happening here was that a PFI agreement was setting up a system to be used by other businesses outside of those contracting parties. And those were the small businesses, the post office branches, and they were the people who in fact were subject to, as Mr. Milburn put it, the transfer of risk. And they had no voice, they had no control and no ability to object. As a consequence of this being a private finance initiative, it was a consequence of this being initially a private finance initiative run and finance program, and then it being a legacy of a private finance initiative, was that the Post Office was not allowed to see the high or low level design of the Horizon system, and was required instead to trust Pathway to produce acceptable outcomes. We ask why no decision was made to reconsider with Fujitsu the nature of the contract and the requirements in relation to access. We agree with the position taken by Mr. Folkes in his evidence that PFI was not a particularly appropriate way for getting a highly complex, bespoke service. The Horizon project demonstrates a failing of the PFI system generally. ICL were commercially motivated, and that then led them to put a positive spin on the appalling failings of the system that they were tasked with providing. They did not act, and it's, we suggest, possible to look at this, that they did not have to act in accordance with any duty of candour that one would expect of a public body or a party to civil or criminal litigation. They did not have a duty of care to the end users, the separate businesses of the sub-postmasters all around the UK. The Benefits Agency was a reluctant party from the outset, and we suggest that they could have acted better. The Benefits Agency was opposed to the BPC system around which Horizon was designed, yet committed to a contract nevertheless, and engaged in a three-way antagonistic relationship with the other parties. You will recall that in his witness statement, Mr. Civic spoke in terms of a long-running saw between BA and POCL. The Horizon scheme was in effect a one-off, never-before-tried, multi-million-pound project of substantial scale and complexity. It should never have been born as a product of a marriage between three parties whose objectives did not align, and in circumstances where one party was contractually entitled to withhold information from the others. And it should never have been born in the circumstances whereby the party that was going to be dealing with the matter and actually handling the system was not indeed part of that three-way contractual relationship. After the Benefits Agency review, the objective of the government, we suggest, was to avoid public scrutiny and damage to international trade. We've no doubt, as we've seen through documents, that there was also the drive to make sure that the Post Office continued and that there'll be changes. We suggest that there is little understanding about the impact in those documents and the briefing documents to the ministers of actually what this system would mean to sub-postmasters. The objective of POCL was to manage its way out of the existential crisis caused by the loss of Benefits Agency revenue and footfall. And the objective of Pathway was to survive the huge financial losses which it had suffered as a consequence of the delays. it was seemingly no one's objective to ensure that the interests of sub-postmasters, who were required to operate the system on the ground, would be presented with a product that was fit for purpose and with adequate training and assistance. Instead, as described by a witness to come in phase 3, that's Bruce McNiven, he puts it this way: it was a leviathan, additionally encumbered by contractual conditions and government scrutiny. So I return very briefly to the 5 themes that we've set out. The inappropriateness of the PFI agreement for the procurement of Horizon. We must pursue with vigour the question of what guidance, protocols and systems were in place to support the use of the Horizon system for civil claims, investigation and prosecutions. As we've heard nothing from the senior management as to any systems being discussed with them or set out for the use of the Horizon product within such claims. What was the depth of knowledge? How far did it go of the problems within the system, within Pathway and then within POCL? And how far there is an impact on those issues with the knowledge of system faults, with decision-making about such issues as the decision taken by POCL to design out the ability of sub-postmasters to interrogate the system. Collectively, the phase 2 evidence may suggest that Post Office was acting dishonestly to cover up the issues and problems within the Horizon system, and that may have occurred from a very early stage. So for this reason, and not the least so that we get to the bottom of this particular matter, we ask that the inquiry continues to seek disclosure, scrutinise the documents with us, and understand whether what happened to our clients was the result of a dreadful but avoidable cock-up, or was this a more sinister cook-up to cover up the fact that the Post Office had bought a system which was not fit for purpose and certainly not fit to support the sub-postmasters, who were then being asked to pay for Horizon system faults in terms of alleged shortfalls and then take the consequences of Horizon system faults in civil actions or being taken before the criminal courts and some imprisoned. So we hope that by making focus closing submissions, if allowed at the end of phases, we will enable the inquiry to move forward with at least the victims' viewpoints at the forefront of its future examination of witnesses. And so I'm very grateful for having this time to address you.
Thank you, Mr. Steele. Mr. Maloney.
So I wonder if I could just very briefly put it on record that we'll be doing written submissions in response to your permission.
Thank you.
Thank you, sir. So we too are very grateful for the opportunity to make brief submissions at the close of the phase 2 hearings. After so many hours of invaluable evidence, these submissions will necessarily only lightly touch on a very few areas of significance. Full submissions on the evidence will only be possible when all of the evidence has been heard. But so far as these submissions are concerned, we divide them into 2 sections. Firstly, Section 1, we briefly address the themes identified in our opening as priorities for phase 2 and to what extent the evidence we've heard has reflected those priorities. And secondly, we consider the questions we posed for phase 3 in opening and perhaps new questions for phase 3 arising in the light of the evidence heard from witnesses in phase 2. We repeat, if we may, sir, how significant this inquiry is for both those we represent and for the public interest. Many of our clients are following the evidence closely as it's given, and others are catching up with the daily recordings and transcripts. And whilst they've often found what they've heard difficult to bear, they also express how vital it is for them to hear it. The trauma of their experiences means that learning how and why the Horizon scandal happened and how it might have been prevented and why it was not prevented has become deeply significant to them. And they are genuinely grateful to the chair and his inquiry team for the care and sensitivity with which the issues in phase 2 have been pursued with witnesses. Moving to our submissions, sir, and I will make them headline submissions and quite brief. Firstly, section 1, themes identified in our opening as priorities and the extent to which the evidence we've heard has reflected those priorities. Firstly, so far as IT is concerned, we won't address the evidence in any detail. Mr. Scipione confirmed that the detailed evidence from witnesses and in contemporary records as to known concerns about the stability of the system and the operation of core applications was solidified by the conclusions he reached in his report. And we consider, sir, that there can be no question that there were known weaknesses, bugs, errors and defects in Horizon from the outset, of which both Paul and Fujitsu ought to have been aware when later decisions were being taken about prosecutions. In opening, we also invited the inquiry to consider additional themes in Phase 2 beyond IT, and they included the adequacy of human systems dealing with the available IT, whether Horizon ought to have continued at all after the benefit payment card was abandoned, and what was known when and by whom. And just briefly taking each in turn, firstly, the adequacy of human systems beyond the available IT. We asked the inquiry to look beyond IT to those human systems, and we say there's been important evidence about that. For example, whether the process of relying on ESHA in the investigation of legacy Horizon issues led to difficulties in the exploration of the root causes of bugs, errors and defects. And we refer the inquiry to the evidence of Mr. Simpkin and Mr. Dalvarez. And the inquiry's also heard evidence of problems in the development of Horizon IT which could be laid at the door of people and not software. And so, for example, in relation to performance and skills deficits, the EPOS task force report and its subsequent consideration by ICL Pathway provides, we say, devastating evidence of the understanding of the flaws in Horizon held by Fujitsu and seemingly not shared with anybody at the post office or in government. The inquiry may conclude that the human and commercial response to this information and the lack of transparency around it in 1998, 1999 and 2000 generates concern. Also, failures in communication and information sharing, both between Paul and Fujitsu, but also beyond the failure of sharing between Paul and Fujitsu. For example, the inquiry has heard from former ministers, including Lord Darling, Sir Ian McCartney, and indeed Mr. Milburn today, that they were prevented from considering earlier evaluations of the ICL Pathway bid by the convention that we've heard about, sir. If ministers were prevented from considering earlier concerns on this basis, it would appear to reflect an expansive and perhaps unhelpful view of the bar on sharing information with new ministers. The inquiry also heard evidence on the limited technical experience held by those making management decisions about Horizon in POCL and ICL. The inquiry may wish to consider whether adequate attention was paid by those in management to people with technical expertise, and we ask you to consider the evidence of Terry Austin and Mike Coombs and David MacDonnell and Jan Holmes in that regard, sir. And the inquiry may also wish to consider whether decisions in government were adequately informed by technical expertise. And we refer you to the evidence of Sir Ian McCartney and indeed Mr. Milburn today on that point. And overlapping to the lack of sharing of information, but separately, there were failures to act. And the inquiry may crucially wish to ask whether accumulated evidence about weaknesses in Horizon were addressed internally, either by POCL or Fujitsu. When confronted with the evidence of the problems, were the steps taken by POCL and Fujitsu adequate in addressing those concerns? For example, it would appear that ICL Pathway took a decision that the cost of maintenance of the system would be more proportionate than rewriting or redesigning the EPOS application. And it's far from clear what this meant in practice, or the active management of the system, or for the work to be done in due course. And that bug-fixing culture remained in place, it seems, and seemingly with the same risk of code regression identified by the EPOS Task Force report. Secondly, in terms of our themes, whether Horizon ought to have continued at all after the benefits payment card was abandoned. The evidence of Lord Alistair Darling on the motivation of the Department of Social Security in walking away, we say, was clear and compelling. By 1998, it appears clear that ICL Pathway was failing to deliver. There were continued problems in testing, and the technology simply wasn't working. And the evidence suggests, we say, sir, that the same conclusion could and or should have been reached in respect of post office automation. And the management of Horizon at this stage raises a number of questions for the inquiry to consider, we suggest. Already touched upon by Mr. Steen were the contractual arrangements, the original contractual arrangements inadequate to allow the Post Office effective oversight of the development of Horizon? Were those arrangements misrepresented or misunderstood in a way which undermined any effective oversight? A number of witnesses gave evidence as to the lack of transparency as to the Horizon solution and blamed the nature of the PFI contract. Mr Miller, Mr Marr, Mr Austin, Mr Folkes, who described it as a black box. And Sir Adrian Montague suggested that a PFI sponsor ought to have sufficient information to enable them to have oversight of the project. The inquiry may wish to consider why the parties took the approach they did to the project and whether, if POCL were unable to adequately scrutinise or to understand the operation, what impact this had both in its development and the decisions which were later taken as to the robustness of the system and the reliability of the data it produced. It might also be asked whether an opportunity was missed in May 1999 for the government and POCL to revisit those contractual arrangements to require greater transparency on the part of ICL Pathway. And it may be asked whether the political decision reached in May 1999 and the contractual arrangements confirmed in July 1999 locked POCL into making Horizon work despite acknowledgement of its weaknesses, bugs, errors and defects. Sir Ian McCartney was clear that he only wanted a properly functioning Horizon, not just any Horizon, but others at POCL and elsewhere may have perceived pressure that Sir Ian did not intend them to feel. And we refer you to the evidence of Stuart Sweetman as to the messaging being sent by Sir Ian, and the evidence yesterday of Mr Colin Baker to the effect that having got it, it's the best we got, so we needed to make it a success. We saw yesterday that while some such as Mr Baker felt they had nothing else, there were strong views being expressed as to the problems with Horizon by those at the sharp end of it at the NFSP conference in May 2000, after rollout had been resumed. And we hope, sir, that we'll see how those concerns were dealt with in Phase 3, because they were important concerns from people at the sharp end of it. And the question that must be asked is whether the political and commercial prospects of failure were simply too great for the weaknesses, bugs, errors and defects in Horizon to be confronted by POCL, by Fujitsu and by government. And then finally in this section, sir, what was known when and by whom? Plainly, given how this scandal appears to have originated and played out, the answer to this question will likely inform all phases of the inquiry's work. The inquiry's heard evidence on the significance of the then Prime Minister's involvement in decision-making on whether or not to proceed, and as we saw this morning, the Prime Minister was told on the 10th of May 1999 by ministers that the Post Office automation parts of Horizon were, quote, ready to roll out and relatively simple. But that message was far from the reality that there had been limited live testing and that testing had already thrown up problems, including in respect of balancing and data integrity. And it plainly didn't take account of the significant number of acceptance incidents, including those which directly affected data integrity and were identified in the summer and autumn of 1999. And it's far from clear that this messaging was ever revisited with government by either POL or Fujitsu. The inquiries heard that the Post Office Board was told that there were technical issues with Horizon. Mr Miller, however, is recorded as having said that the system was robust in July 1999, and issues were later raised with the board in September 1999 and again in January 2000. The inquiry may wish to consider the significance of the information provided to the board or not provided, and whether the actions taken by the board were at this stage appropriate. And the terms of the third supplemental agreement make clear that it was accepted that the Horizon system would never be perfect. And the inquiry has heard evidence that there were accepted tolerances for failure, which the inquiry may wish to consider, given the use to which the data generated by Horizon was subsequently put. There's consistent evidence that little or no consideration was given to the role which Horizon would ultimately play in prosecution during that system's development, nor indeed civil actions. where there was consideration of the contractual provisions in relation to PACE compliance evidence, there appears to be very little activity or understanding of the significance of those provisions. And the inquiry is invited to consider whether this was a critical oversight in the decision making during the course of moving forward with Horizon. But by contrast, there was evidence that senior management at the Post Office were aware of the prosecutorial functions of the organisation. For example, Mr. Evans, the company secretary. And Mr. Johnson was well aware of the prosecutorial function of Post Office, but did not think that the operation of Horizon would be relevant in that context. And moreover, a lot was at stake in May 1999 for all of the parties involved. Witnesses from ICL and from POCL accepted that that was the case, and indeed from government accepted that was the case. They confirmed that the loss of revenue from the benefits agency would create an existential crisis for POCL. And a lot remained at stake in early 2000 when the decision was taken to roll out Horizon on a national scale. And the inquiry may ask whether by the end of 1999 and into early 2000, when crucial decisions were being taken, the focus adopted was too inflexibly Horizon-centric, and that other approaches were being ignored. And that critical analysis of Horizon, produced for ICL and for POCL and the benefits agency, was ignored or explained away, despite significant concerns being raised. There was evidence from a number of witnesses that by early 2000, the commercial opportunities for the development of Horizon were paramount, and there appeared to be a combination of imperatives acting to ensure that Horizon rolled out, including the need for inward investment to continue and grow, the need for ICL to survive, and the need for POCL to become automated, both for POCL and the SPMs, who had £1 billion of their own money invested in it. In those circumstances, it may be that Horizon could not fail, that it must be made to work. Secondly, sir, just for a few minutes, Phase 3 and beyond, our second section, where we identify some of the more central questions we posed for Phase 3 in opening, and new questions arising in the light of the evidence heard from witnesses in Phase 2. Just a couple of the matters we raised in opening for Phase 3, which the inquiry may wish to consider in the evidence to come. We identified as a key aspect of the evidence potentially was the reliance on professional reports, advice and reviews. And we identified in opening 2 examples for consideration which resulted in troubling evidence emerging. Firstly, the Montague review. We simply say about that, sir, at this stage, that the Montague report was not adequate basis for any conclusion that Horizon was robust. And secondly, the Project Mentors report, sir. The inquiry has heard evidence on the limited dissemination of the work of Project Mentors and the action taken on it. The inquiry may yet consider that the Project Mentors conclusions were highly relevant in the context both of the work done by the Montague panel, the information available on problems emerging in testing, and the early evaluation of the ICL pathway bid. And it might be asked whether the approach to this reporting was illustrative of the treatment given to any substantive criticism of the reliability of Horizon during its development and beyond. Secondly, in opening, we asked whether the inquiry might consider whether opportunities for justice at an earlier stage were missed, whether justice was delayed. Regrettably, the evidence of Phase 2 already suggests that there were many opportunities to walk away from Horizon, or rather, perhaps, to identify that its data never could and never should have been relied upon for the purposes of prosecution nor civil actions. That would include in 1997, when Pathway were in breach of contract, in May 1999, when the Benefits Agency withdrew from the contract, in September 1999, when POCL chose to accept Horizon despite a failure to meet the criteria for acceptance, or in January 2000, when the decision was taken to roll out Horizon on a national basis on the basis of the third supplementary agreement. The evidence in Phase 2 begs the question as to what information was provided to others who've previously been asked to consider Horizon. For example, was Second Sight or any other reviewers ever permitted to see the original evaluation of the ICL pathway bid? Was Second Sight ever provided with copies of the project mentors reporting? Ever told about the EPOS task force report? And what access to Fujitsu were other reviewers allowed? And as we identified in opening, sir, plainly an important question which arises on the evidence we've heard in phase 2 is what measures were in place within POCL and, of course, as we come into phase 3, Post Office Limited, and within Fujitsu to ensure that the knowledge gained during the development of Horizon about its potential weaknesses, bugs, errors and defects informed individual and collective decision-making about Horizon and its operation, and in particular about the Post Office's approach to prosecution policy and its approach to individual audits, investigations and prosecutions. And that, we say, is likely to be a very important question for phase 3, sir. At least some of those providing evidence in phase 3 are persons who appear to have been involved in the development phase of Horizon and who may be able to explain what was done with the knowledge of Horizon's weaknesses as matters move forward. And the inquiry in phase 3 may wish to explore in particular what impact this learning had both in the customer service support provided by Fujitsu, and we anticipate Mr. Mukau, who was named by a number of Fujitsu witnesses in phase 2, including Terry Austin and Alan Dalvaras, will be able to address that, and in the involvement of Paul in the operation and modification of Horizon, which we anticipate may be addressed by Mr. David Smith, amongst others. It may be that some witnesses from phase 2 have to be recalled, but those we represent have a particular interest in understanding what knowledge about the development of Horizon was available to those within Fujitsu taking decisions on the provision of evidence for the purposes of prosecution. For the avoidance of doubt, this issue isn't limited to individuals and their role in preparing audit data and giving evidence in court. The inquiry is invited to consider in phases 3 to 5 what systems were in place which could or ought to have provided real information, reliable information for taking decisions as to prosecution and civil actions. And as part of that, institutional memory, we say, will be an issue which our clients will find important. We note, for example, an important part of the evidence was that at the end of the development of Horizon, a number of key personnel were moved both within ICL Pathway and at POCL. David Miller changed jobs mid-rollout. And of course, that may have affected the way in which the faults relating to Horizon remained known to those making crucial decisions. And the inquiry may not wish to limit its consideration of institutional memory to POCL and ICL, but may also wish to consider whether the National Federation of Sub-Postmasters should have had a better recollection of what was happening during the development phase of Horizon when sub-postmasters began to be prosecuted. And to that end, the inquiry may wish to hear further from the NSP in phase 3. Beyond this issue, there have been many matters arising from the evidence in phase 2 which may encourage further questions for exploration by the inquiry. And we briefly highlight only 4 issues. Firstly, training and the help desk. The inquiry has heard repeated evidence that sub-postmasters were told that they were the only person to have experienced what they were going through. The inquiry may consider that this simply could not stand up even on the evidence heard about pinnacles and peaks generated during the development of Horizon and beyond. And the inquiry may wish to consider the training for people on help desks as well as the training of sub-postmasters. Secondly, contracting evidence and the Police and Criminal Evidence Act. Repeated evidence suggests little or no attention was paid to this aspect of the operation. Thirdly, the management of audit data and evidence. The inquiry has heard a little so far about the availability and accessibility of audit data from the Horizon system, but it may be that this becomes important within phase 3 as things move on. And finally, pinnacles and peaks beyond December 2000. The report of Mr. Scipione was limited to the end of 2000. The question of what was known about the bugs and when, as things went forward, is something that the inquiry may wish to consider. So, sir, our clients are grateful to the Chair and the inquiry team for their considered work on phase 2. The evidence gathered in phase 2 forms a crucial backdrop to the decisions taken within POL, which impacted upon each of our clients' lives with devastating effect. The detailed consideration of disclosure by the inquiry team and by other core participants has been crucial to the effectiveness of this phase, and this is work each of the sub-postmasters we represent anticipates that the inquiry will continue with the same commitment, rigour and care that has been evident in phase 2. And as with phase 2, we'll seek to assist in any and every way we can.
Thank you. Are there any sweeping up points, so to speak, Mr. Pierre?
Yes, just one from me. There are a number of witnesses, sir, whose statements are relevant to phase 2 of the inquiry and may be taken into account by you in due course, even though they've not given evidence in this room orally in phase 2. These statements have all been disclosed to the core participants. I'm going to list them in a moment. But by this announcement, I should indicate that they are to be taken as read into the inquiry's record, even though I'm not going to read the contents of them out now. They will be uploaded to the inquiry's website if that has not already happened, because the witness statement has been referred to in the course of the evidence of a live witness. So there are 9 of them. They are the statements of George McCorkle, the URN of which is WITN 04170100. The witness statement of Mina Rigo, WITN 04130100. The witness statement of Robert People, WITN 04020100. The witness statement of Ruth Reed, WITN 05210100. The witness statement of Simon Folkes, FAWKES, WITN 04830100. The witness statement of Peter Jobson, WITN 0482. The witness statement of Sir Anthony Blair, WITN 06080100. The witness statement of Peter Crahan, CRAHAN, WITN 04160100. And the witness statement of William Patterson, WITN 06650100. So thank you very much.
And the only thing that I'd like to say before formally closing this session is that those who have been following closely will have heard me say on a number of occasions that I am paying close attention to disclosure issues. Currently, there has been disclosed to core participants 2 disclosure statements from Post Office. They have provided a 3rd disclosure statement to the inquiry, and that will be published early next week. I have also received a disclosure statement on behalf of Fujitsu Services, which I believe has been disclosed to core participants. All those statements are now under review, and if I feel the need to take any further action in respect of them, I will do so and let everybody know as quickly as I reasonably can. It therefore remains for me to say provisionally that phase 2 is now at an end, and I look forward to meeting you all on Thursday for a slightly different topic. and I look forward to seeing you all in the new year. Can I just clarify before finally closing that Ms. Page has said that on behalf of her clients there is to be a written submission about phase 2, and I'm aware that Bays are doing the same. Is that correct?
Yes, indeed.
But I take it that that is the extent of written submissions.
No, sir. We are also doing some written submissions.
Right.
We did inform the Inquiry Secretariat in
Well,
accordance
then
with the
it's my
direction.
mistake, not
No,
yours.
no, but
sure
I'm
that
afraid you're not
it's
spared from
covered.
ours.
And the same for Fujitsu, sir. On
Right.
the same basis, we've informed the Secretariat.
So I was looking forward to some time off before Christmas, but that seems a forlorn hope. So on that happy note, we will now close for the afternoon. Thank you.